Next, taking up the case of the state of Michigan versus James Francis Salter Jr. This is case number 25-14087-FC. Appearances from counsel, please.
Jay Carnes on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Mr. Salter. He's joined me at the table.
All right, thank you. Mr. Salter is here currently in pretrial custody. We are here today for a sentencing after a jury verdict. One moment. Yes, that jury verdict came in on December 18th of 2025. Also before the court this morning is Mr. Charles Kennard from the Michigan Department of Corrections, standing in for Mr. Van Atmel, who prepared today's pre-sentence investigation report. Let's begin with taking a look at the PSI. Mr. Carnes, did the people receive a copy? And did you have any amendments, corrections, or objections to make to the contents of that report?
Your Honor, I did. One thing I noticed was that in the initial pages, the SIR 88-1, CFJ 145, talking about convictions 1 through 16, but then in CFJ 284, we start talking about counts that range from 1 to 23, with there being some gaps. I found that confusing, so I constructed this table. I would ask the court to consider making that an addendum to the PSI, just so it's clear.
And Mr. Carnes had informed myself and Mr. Harrison via an email, I think a week ago, that this was coming. I don't think you attached it to it, but if you did, I apologize. I didn't print it off because it would have been ex parte. But Mr. Harrison, do you have any objection to it?
I do not. I have reviewed that. It does appear to accurately correspond.
And that's based upon the felony information as it ended up, because there were several changes to the felony information during the trial.
And that's where I was going to hedge my bet, Your Honor. As far as I can tell, it corresponds.
All right, thank you. And again, there were also changes to the verdict form that came out based upon changes to the felony information based upon the testimony at the trial. All right, thank you. I now have a copy of that, and it does help specify counts from based upon the convictions, and then the counts based upon how they appeared on the felony information. Mr. Carnes, did you get a copy of that?
I haven't, Judge, but I'm going to.
Okay, all right, thank you. All right. So, Mr. Carnes, let's go back. Any other amendments, corrections, or objections to make to the contents of the pre-sentence investigation report?
No, Your Honor.
Mr. Harrison, how about you, sir?
I have one, and it's terribly nitpicky.
Okay.
It appears on CFJ 284, page 25. In the middle of the page, there's a table that addresses family. They have misspelled James Salter Sr.'s middle name.
Okay.
It is indeed Francis. There's an extra letter in there with a Q.
Well, if that's all we got to change.
Well, and there's
I got
one
it.
more.
Okay.
Again, it sounds terribly. I think the phrase is arranging deck chairs on the Titanic, but we'll save that for another day. The name of his mother, Linda Lou Harriet Salter, is also misspelled.
Oh, so right now it says Linda Lon, it's Linda Lou.
Yes.
So change the N from an O to a W, or I mean a U.
You.
All right, and that's good. I don't mind the details. The nitpicky part, that tells me that the parties have gone through this report with a fine-tooth comb. 1 second here. As the court begins, I'm going to turn it over to some statements here in just a moment. I occasionally find it important to note that when the court does issue a sentence, there are things entered in the prior criminal history. Clearly, Mr. Salter, I note that some of them were dismissed. I want you to know that when I take into consideration the prior criminal history today, I clearly do not count any case for which you had a dismissal. To me, it's as if it never happened. All right, Mr. Carnes, any victim impact statement, sir?
Yes.
All right. Folks, you're going to approach the podium right there. You can come one at a time or both, whatever makes you feel comfortable. Now, when you speak, I'm going to ask each one of you to speak one at a time. And I'm going to ask, even though I remember your names, just to state them for our record. Ma'am, your name?
Melinda Morin,
And spell it for me.
Melinda Morin.
Yes, ma'am. And you?
Allie Morin, Allymorrin.
All right, thank you. Melinda, what would you like to say to me? Take your time. Take as much time as you need.
I have experienced unlawful and traumatic events at the hands of James Salter Jr. Due to those events, I currently struggle with many side effects and mental ailments that have deeply affected my life. When I first got away from my groomer, the world was big and overwhelming. I struggled heavily with adjusting to a non-abusive and non-trapped environment, and I found myself feeling overwhelmed, scared, confused, and emotional. I also struggled with self-harm and suicidal tendencies. I signed up for therapy because I wanted to understand what was wrong with me and why I felt the way I did. I was quickly diagnosed with severe depression, severe anxiety, and PTSD. PTSD is post-traumatic stress disorder. It's a generalized mental illness which has many side effects, some I live with day to day. The actions and events James put me through did not go away in my head. They replayed over and over when I tried to sleep, when the room was too quiet, when there were too many people around, or when something triggered memories I couldn't control. In those moments, I was back in those situations all over again. Sleep itself became something I feared. I found myself waking up in tears and sweat, gasping for air and panic, sometimes screaming because I was afraid it didn't go away, that I was still living that nightmare. When I wake up, I'm completely disoriented due to the impact of the nightmares due to the impact the nightmares have on my mental health. Sometimes I'll be afraid to go to sleep and I find myself avoiding it. Staying up as long as I can until my body can't stay awake any longer, because there's always the thought of, how do I know if tonight's the night I have to see him again? The fear is exhausting and consistent. Unfortunately, this is not limited to sleep. Even now, everyday situations can trigger my anxiety, panic, and fear. I struggle with feeling unsafe in ordinary environments, even when I logically know I'm safe. My mind consistently races with the thoughts of, how do I know? If doors are closed in my house or where I work, I start getting scared of that room or area. Because how do I know he's not hiding, waiting for me to be aware, not waiting for me to not be aware and hurt me or take me away? He could be in my shower, he could be in my closet, he could be waiting for me to unlock my front door. Even now, when I know it's impossible for him to be waiting, I still get scared. I'm paranoid when I leave the house. Similar to my fear of closed doors. How do I know he's not in the next aisle or in the next booth? Will he get far if he grabs me? Will someone be strong enough to save me? I don't even feel safe in my own bathroom. I checked the lock multiple times because how do I know he's not waiting on the other side? I struggle a lot with, how do I know and how do I know I'm safe? I have good days and bad days. Some days I have energy and motivation to work towards my goals and live my life. Other days, I can't find a reason to get out of bed. My body is so heavy, I don't have the energy to stand up, and I go through my day in a blurry motion. Flashbacks and intrusive memories interrupt normal moments and have forced me to relive experiences I desperately wish I could forget. I could be driving, cooking, hanging out with my friends, walking through an aisle, and smelling a smell or hearing something on TV. And I'm reminded of something and then replaying those dramatic events all over again. I can't control when they'll come or what they'll be. It takes up my time and my mental space, causing me to think about it most of the day afterwards, just trying to process it. I'm doing my part and being proactive in my mental healing, but it comes at a cost. I see my therapist every 2 weeks and sometimes every week if I'm struggling extra. I have to take time off work to do this and it isn't free. It's mentally and financially taxing. I currently owe almost $2,000 to my therapist because sometimes I can't afford the copay, but I also can't afford not to make my appointments. I need the consistency to function. There's a strong possibility that I will continue to struggle with the effects of this trauma for the rest of my life. What happened to me cannot be undone. The fear, anxiety, and psychological impact remain things I must manage every day. I wanted a dad, I wanted a friend, I wanted a safe person. I didn't get that. He showed me at a young age that monsters do exist and they sneak into your room at night when the house is asleep. Although I cannot easily put everything I struggle with onto paper, these are some of the main effects that I live with due to his actions. I did my part. I turned him in for what he did to me personally and what he did to my sister. I went through horrific things at the hands of my groomer, and I don't want another little girl who's looking for a dad to end up like with a monster like I did. For these reasons, I respectfully ask you to consider the seriousness and lasting impact of what I've endured and to impose punishment to the maximum extent of the law.
Thank you, ma'am. Ashley, how are you doing? Are you just wish to make a statement? All right. You take as much time as you need. Thank you, ma'am.
I have experienced horrible acts from James Salter Jr. And because of that, I lost and gained many things from my childhood that no person should ever experience in their life. I was a child trying to survive in a house that was supposed to be safe and loving. Instead, I was in a house where I didn't feel safe, a house I wanted to run away from, and a house that I never wanted to come home after school to. During therapy, I was diagnosed with multiple illnesses, and I was told that there was a possibility I may never stop having night terrors. I started therapy to get help to manage my constant anxiety from loud noises, the feeling of being watched, learning not to feel everything, learning not to feel that everything is my fault and trying not to hate myself. My anxiety was so severe that I would even vomit and have panic attacks on a daily basis. I consistently felt like I was being watched. When I saw a vehicle similar to his, I would immediately panic. He used to call me names, and I eventually began to believe they were true. Every time I tried to sleep, I would wake up screaming and crying from the nightmares. I would be drenched in sweat and struggle to fall back to sleep. The nightmares felt so real that there were days where I would not sleep at all because I was too scared. My therapist told me that I'll most likely never completely get rid of the nightmares, and that I'll be working on them to prevent them from taking control of my life and learning how to regain control. I struggle on a daily basis when my dogs are moving or scratching on my bed because it triggers memories of him hurting my sister when we shared bunk beds. I struggle to look in the mirror, seeing the reminders of where he hurt me sexually, physically, and mentally. When I use the bathroom, the door must be always locked, and when I shower, the curtain either has to be completely closed or completely open. Even a slight gap causes panic because of the times when he watched me shower or use the bathroom. My room is always clean. If I had anything I hadn't used or worn in a month, I would get rid of it. I was never allowed to have a messy room. If my room was dirty, he would hurt me or throw my toys away, and even if I was still playing with them. If I truly liked something, he would burn it, give it away to his family, or break it and throw it away. Now, when I have money to spend on myself, I struggle of the idea of owning things or receiving gifts because in my eyes, they never truly felt like they were mine. They felt like weapons in his hands. I can't sit anywhere in the car except in the back passenger seat because I get really nauseous and car sick if I sit anywhere else in the back of the car. James trained me to sit there so he could reach me to pinch me if I fell asleep or just for fun. I wanted a dad, someone to protect me and love me, not someone who abused me in so many ways. I did not want any child to go through what me and my sister did or live with the lasting effects we may have. He targets mothers who are looking for love. Many may not notice what is happening until it's too late, may not fully believe it, or may not care enough. Because of this, he will continue to harm others if he doesn't receive maximum punishment. There is so much I cannot put into words or categorize, and so much that's happened that will take years for our story to be fully told. I only hope this is kept in mind when those who support him and consider carefully would determine his punishment. Thank you.
Well, if you take a deep breath, all right? Thank you very much, ladies. You may have a seat. Mr. Carnes, allocution on behalf of the people, sir.
Thank you, Your Honor. Throughout the trial, we had heard both Melinda and Allie recount the horrible treatment they endured from defendant. Allie's physical abuse included being beaten with a baseball bat, being hit so hard by a can of shaving cream thrown by the defendant that her head began to bleed, and she still has a scar from that today. She was thrown across rooms or garages, and she was chased by the defendant while she ran up a hill and he followed her on a snowmobile or a quad, getting so close she was worried he would kill her. That physical abuse was echoed by the defendant's niece and nephew in interviews with MSP that Agent Van Ackmel included in the PSI, and I think it shows just how much these are cycles that are in the defendant's life. It shows that the defendant just won't stop. Melinda recounted how she was groomed starting at the young age of just 10. She was molested at age 10 or 11, violently raped starting at 12 years old. I'm just waiting for the defendant to
I know.
Thank you.
All being ripped off. Mr. Salter?
We talked about this, okay?
Yep. Mr. Salter, I understand what you planned, and I understand that it's difficult for you. Please maintain proper decorum in the court. Expect that will be my only warning. All right, Mr. Carnes, you may continue.
Thank you. Melinda testified that she was violently raped starting at age 12, and that continued until she escaped around age 21. Melinda's testimony also described acts of violence. She was beaten and choked when she resisted the defendant. I noted that age of 10 because, again, the pre-sentence investigation report includes a summary of an interview the state police had with the defendant's sister, where she disclosed being molested by the defendant when she was just 10 years old and he was 19. Clearly a pattern because another brave witness at this trial, a minor child with the initials AG, described being molested by the defendant as recently as April 2025. I believe AG was 11 years old at that time, but she disclosed that the defendant began grooming her and molesting her at age 10. The defendant's behavior over the past 22 years demonstrates that he will continue to sexually assault 10-year-old girls if left to his own devices. Whether he's learned anything through this process, it seems, I did note in the PSI that Justin Miller, inmate at the Wexford County Jail, sent Agent Van Ackmel a note saying that the defendant told him that next time he would just murder the victim. I'm begging this court to make sure the defendant has absolutely no shot at a next time. The defendant stole childhoods from Melinda, Allie, and others. Left lasting impacts, as Melinda and Allie just stated. Melinda can't sleep right. She can't live her life normally. She has issues feeling safe in the world. In a house where she should feel safe, she experiences panic and concerns that the defendant could be there when clearly there's no chance of that, but in her mind, she can't put that out of her mind. Allie continues to experience panic attacks, problems with self-image, and struggling to feel in control of her feelings. In convictions 1 and 16, Melinda testified that the defendant would penetrate her first with his tongue and then with his penis when she was just 11 or 12 years old. Allie's testimony made it clear that she heard this happen on several occasions. Allie told police that she could hear her sister cry while the defendant raped her. She testified at trial that she would kick in the top bunk of the bed to try to stop him, and the defendant would grab her leg really hard. It hurt, and he would threaten her. Melinda testified here about one particular occurrence that makes up convictions 1 and 16, but she also testified that this sort of thing happened to her repeatedly. So convictions 1 and 16 are both CSC first and a first-degree victim less than 13, and they both occurred on the same transaction or occurrence. The court has discretion to sentence the defendant consecutively for these crimes. It must state reasons for the consecutive sentencing. Here we have the defendant starting to rape Melinda. She cries. Her 5 or 6-year-old sister hears her cry, and the defendant continues to rape Melinda. I think those are very good reasons for consecutive sentencing for counts 1 and 16, and I would urge the court to sentence at the top of the guidelines on both of those to 562 months for each of them. In convictions 2 and 3, Melinda testified that the defendant penetrated her with his tongue and then his penis. This is a first-degree CSC first because of the relationship and because Melinda was 13 to 15 years old at the time. But Melinda also testified that the defendant would beat her, would threaten her with physical violence, and that she has suffered lasting mental harm. So there are multiple reasons for this to be a CSC first. She still receives counseling to this day. And again, Melinda testified about one particular occurrence that makes up convictions 2 and 3, but she also testified this happened regularly. I think those are all good reasons for sentencing the defendant consecutively for counts 2 and 3. And again, I would urge the court to issue a sentence at the top of the guidelines, which in this case would be 427 months for each count. Convictions 6 and 11 deal with strangulation and criminal sexual conduct in the first degree due to injury and force or coercion. Here, Melinda testified that she resisted the defendant. This happened that when she was, I think, 18 or 19 is what she testified. And after she resisted the defendant, he choked her and then he raped her. Again, this was accomplished through violence, dangerous violence. Strangulation is a serious crime for a reason. It can cause lasting damage, even death. And this occurred because of years of manipulation and grooming. Again, I think those are all reasons for consecutive sentencing here for the CSC first and strangulation. The CSC first, I would urge the court to sentence to the maximum of 427 months and strangulation to 100 months consecutively. There are clearly a bunch of other counts here. I would urge the court to sentence at the top of the guidelines for all of those counts as well. This is the most horrific case of my career so far on either side, and it was troubling. And again, the defendant needs to be stopped. Clearly, the testimony and the PSI makes it clear that the defendant is in a cycle that he will not stop on his own. it is up to the people to stop.
Mr. Harrison, elocution, sir.
This is a day that no defendant or defense lawyer looks forward to. There's no clear path or clear guidance as to what, if anything, the defense lawyer should say in support of his client, especially in light of his maintaining his innocence and looking forward to speaking with an appellate counsel and in light of the witness or the victim statements that we all heard this morning, in addition to Mr. Carnes' elocution, I would say a couple of things. That the difficulty in looking at just the vast amount of months that are potentially on the table here, it's simply an easy knee-jerk reaction to say, yeah, he's a monster, put him away for as long as you can. On the other hand, it's also difficult to look at material in the PSI that has not been tested for any evidentiary value in light of the multiple instances of testimony that actually did take place in the trial. Now, that comment is not meant to get anybody fired up. It's just a statement.
What is in there that didn't come out at trial?
Oh, there are statements from people that did not participate in the trial, such as Mr. Salter's sister and his niece, et cetera, et cetera. I often make this same remark upon the completion of a case in which there is a conviction by a jury's verdict, because I think that's important to note, maybe less so in this case than in the usual one, that those were not the things upon which the jury made its determination. The finder of fact, the applier of the law to the facts of this case.
What was the sister's name again?
Michelle.
All right.
It's just an observation, Your Honor, and I think it bears some examination for whatever impact, if any, it has on the court in fashioning a sentence here. We have to bear in mind that proportionality is still in play. Ordinarily, and this is one of those rare instances where I don't believe it's appropriate to do so, I would speak to perhaps some mitigation, but in light of Mr. Salter's continuing insistence upon his innocence, to which he is entitled, again, that's not expected to inflame anybody. It's not expected to change anybody's perspective on it. It's just a fact of the situation. I encourage the court to apply the wisdom imparted to it in this regard and to fashion a sentence that is both accurate, proportional, and in accordance with the usual considerations in any criminal case. Thank you.
Thank you, sir. All right, Mr. Salter, we're at that time now. If there's something that you wish to say to the court before I issue a sentence, now would be the time. And thank you for remaining quiet after I last spoke with you. I do appreciate that. And I recognize that you comply. Is there anything you wish to say at this time, Mr. Salter?
Just maintain my innocence, Your Honor.
All right, thank you.
Want to do my appeal.
And you have that right, and we'll go over that in just a minute. And, would never say anything to discourage anyone from filing an appeal. All right, so this case began in 2025, was tried in December of 2025. Throughout the entire processing of a criminal case, judges don't apply a whole lot of discretion. My professional discretion, even personal, doesn't come in until right now. I make rulings on motions that are presented to me by the attorneys. I make rulings on evidence during the trial, what's admissible, not admissible, questions that are asked, objections that are raised, things like that. It's now time for the court to apply its discretion. When I do so, I'm always conscious that there's nothing I'm going to say that's going to make anyone feel better. Can't do that. Words don't have magical effect here from a judge. It's going to be, I think the sentence will be fair and appropriate, but there's nothing I can say to Allie or Melinda that will take away the scars that they have and that they will continue to bear and deal with, and new ones that will come up down the road, because they're quite obviously so deep. And while they're getting counseling, the depth and the impact on them and their lives may not be fully discovered. So I know that my words today are probably going to fail and have any magical effect. But I'll say this: their testimony during the case was very strong. They spoke clearly. They talked about significant details that were very difficult to talk about in front of strangers. I remember their testimony quite vividly. And I say that not to make a judgment about credibility, but maybe I do, just to tell you the strength that they showed in testifying was great. Whenever you see sexual assault cases that involve children, sometimes they don't come out for a while, and people want to understand why. And I remember here we had Miss Welke, an expert who testified. Is that right, Mr. Carnes?
Yes, sir.
And she did a very good, thorough job at explaining how it impacts young people and how they may not say something for a while, how they may keep it quiet because they fear the assault being turned upon another child in the home, how they start to see that that is their reality. For instance, sexual assault upon anybody is terrible, but when it's upon, say, another adult woman, she has an idea of what life is supposed to be like. But when you're raised in this environment, as we saw here, you cannot judge how they see the world. Their reality is not the world that I grew up when I was a kid. Right? My world revolved around Saturday morning cartoons, which I know they don't have anymore, and sugared cereals and running around the neighborhood. Yours was not that. So whenever I talk about discretion and sentencing, I obviously take this fact as the jury determines the facts of this case. And it was quite clear. The jury agreed with the victims. And therefore, what that jury found is, according to the law, fact. And that's what I look at. I don't question it. It's not my job to question it. That is the fact. I remember Miss Urusco's role in this case, and that was quite convincing. And the recording of the defendant in the background trying to get to Melinda. And that was a very important piece of the case. I'm quite certain that the jury really considered that an important fact because they could actually hear the defendant in his own words. Now, there is something here in the pre-sentence investigation report. I know Mr. Harrison mentioned it, not referencing some things that weren't tried in the case, but the court is allowed to make findings based upon a preponderance of the evidence. Since no one asked for a hearing to challenge or strike that language, which is why we go through, we meet in courts and ask the parties if they have any objections to the content. The answer was no. Therefore, I make a finding by the preponderance of the evidence that those things that are contained in the pre-sentence investigation report, I can consider at sentencing. So I do. I remember the other act's testimony from the other young child whose initials we just used today as AG. The orange sherbet colored looking costume dress and the stuffed animal she had sitting on her lap, I think was very memorable. I know the jurors took it into consideration clearly. I could see even the confusion on the way some of the questions were being asked of her and how she was answering them. And Mr. Carnes picked up on that right away, changed how he was asking the questions so the young girl could understand them. And then she nailed it out of the park. The stories here are horrific, and there's nothing that I can say that's going to make it go away. But the young ladies out there, you have a group of family members and friends who care about you. We don't go through this world alone for a lot of reasons. That's why God gives us family members and community, because it's only when we work together that we can help each other. You folks did nothing wrong. That doesn't make the scar go away. You did nothing wrong. You are still very young and you have a lot of life to live. And I hope that you'll be able to put this behind you. And the strength that you showed today and during the trial was quite impressive. I'll go back and comment again on the impact of such crimes upon young people. Every person is unique and deals with things in their own special way. And it would be easy for someone to look at testimony and say, well, I don't have this, I don't have that. You don't really understand what it means to have gone through this. And again, I'm just beating a dead horse here. You guys testified very clearly. You brought an emotion into the courtroom, and it was very real. I think that's why the jury found the defendant guilty. And while I don't know if I could call a defendant or any person a monster, because as a judge, I have a philosophy, and that is there's only ever been one perfect person to walk this earth, and ain't any of us that person. So I even try to hold out hope that every sinner can find the ability to find rehabilitation. And I leave that up to the defendant. All right, so it's time for me to stop rambling. I will remember that trial for a long time. All right. The court assesses $68 state minimum fees is required by law. A $130 crime victims' right fund fee. I'm not going to assess any other fines or costs. Well, hold on, yes, sir.
$90 HIV.
Thank you. I was just going to ask about that. There is a $90 HIV fee, but we already had a DNA presumably from prior convictions. Is that correct?
That is correct.
All right, good enough. So there's a $90 HIV fee. Okay. All right. As Mr. Carnes mentioned, counts what is listed at, and I'm going to go through these for the clerk and for the council and for the Department of Corrections. I'm going to use the conviction numbers that are listed on or as they are listed in CFJ 145, not as they were listed underneath CFJ 284, which were for the counts as they appeared on the felony information. So again, for counts 1 and 16, again, these sexual acts of penetration began under the age of 13. You can't take that away. You can't undo that. Court sentences the defendant here, recognizing that there is a mandatory minimum of 25 years. The court finds that that amount of time is insufficient because this wasn't one time. This began as a lifestyle. That's what it was. Court sentences the defendant at the top of the guidelines of 562 months. And it could be up to life or any term of years. The court is going to set it for a term of years or a lesser term, and I'll use months again. The court sentences again to the top at 600 months. And that sentence applies. Well, I'm just going to do one thing. That's count one. As for count two is a charge of CSC in the first degree based upon a relationship. And here, the court sentences the defendant at the top of the guidelines at 427 months. And the court will set a maximum of up to 600 months. For count three, again, another charge of criminal sexual conduct in the first degree. Here, the defendant is sentenced to 427 months to 600 months. Count four is a charge of criminal sexual conduct in the second degree upon a child under the age of 13. Here, the court sentences the defendant to 120 months to 360 months. As to count five, another charge of criminal sexual conduct in the second degree. Make sure I'm looking at there we go. Court sentences the defendant to 120 to 360 months. Next, as to count six, this is a charge of assault with the intent to do great bodily harm, strangulation. Here, the court sentences the defendant to 100 to 240 months. That is within the guidelines at the top. As to count six, correct?
Mm-hmm.
Yeah, thank you. As to count seven, this is another count of criminal sexual conduct in the first degree. Here, the court sentences the defendant to a prison term of 300 to 600 months. As to count eight, the charge is criminal sexual conduct, child abuse in the third degree. The court sentences the defendant to 24 to 48 months. For count nine, another charge of child abuse in the third degree. The court sentences the defendant to 24 to 48 months. Hold on a moment. I need to make note that the court exercises its discretion to sentence the defendant as a third habitual felony offender for counts 8, 9, and 10. That 48, Mr. Carnard, that 48 months listed underneath the statutory maximum, is that as the habitual offender third? Is that right?
Yes, I believe.
All right, good, thank you. I just needed to make note that I'm exercising the discretion as the sentence of third habitual. All right, so if I remember correctly, we were at count. And of course, did I get through? We're not through 10 yet, right?
You are on 10.
On 10, thank you. Here again, the court sentences the defendant to a prison term of 24 to 48 months. Now the court continues as to count 11. Count 11 is a charge of criminal sexual conduct in the first degree. And there is a third habitual felony enhancement here. Oh, by the way, the court exercises its discretion to sentence the defendant as a third habitual felony offender as to all counts. I just should have said that, Madam Clerk. Thank you. All right, so again, as to count 11. Here, the defendant is sentenced to 427 to 600 months. Again, the maximum could be up to life or a lesser term, and the court finds that the 600 is an appropriate maximum. Also, we're moving to count 12. This is now a child abuse in the second degree as a third habitual felony offender. And here the defendant is sentenced to 120 to 240 months. Count 13. This is for another charge of child abuse as in the second degree. Here, the defendant in this particular charge is sentenced to 100 to 240 months. Turning to count 14, another charge of child abuse in the second degree as a third habitual felony offender. And again, the court sentences the defendant to 100 to 240 months. As to count 15 of 16, another charge of child abuse in the second degree as a third habitual felony offender, the court sentences the defendant to 120 to 240 months. And now we're down to count 16. Count 16 is another charge of criminal sexual conduct in the first degree upon a person under the age of 13. Here, the court sentences the defendant to 562 to 600 months. Each count, the defendant is given 271 days of credit. Now, there's still the question about the exercise of this discretionary consecutive sentencing. One moment as I consider some math here. The defendant is 40 years of age. Right now, as I'm doing my math, we're looking at approximately a minimum sentence of about 48 years. Is that about right, Mr. Kennard?
Yeah, about 46 years, Judge. Just
46,
over.
yeah, thank you.
Okay. Minus the good conduct time, it's about 45. That means he cannot get out of prison until he has served the minimum. And that means he's about 85 years of age. In these cases, you often hear people say, well, we should just hang that person. We should bring back the noose and so forth. And I do understand where people come up with that concept. I completely can't necessarily disagree, but that's a very emotional response. The court also considers the potential issues for appeals and things like that. And I automatically go into the sentence an automatic appellate issue.
Again, this is a case where even by the time the defendant gets out. Mr. Carnes, could you remind me how old is Melinda?
She can tell you that.
22? 4? All right, thank you. I see your head shaking her head. So she's gonna be in say a woman's age out in public, like 69 or 70 years of age by that time. I did not anticipate this consternation. 1 second. Again, these are bells that cannot be unrung. These are scars that I hate to say negatively that they can't be healed, because I want everybody to leave this courtroom and be positive. I want them to realize and believe that scars can be healed. Take it away. Again, the severity of these acts beginning at such a young age, and Melinda calling him a groomer is exactly what he was. He was grooming her from a very young age, and then carried the relationship basically after mom left, made her a significant other. And when she tried to pull away and went to another house, he went pounding on the door, professing how important that he was to her and how she was his. Words to that effect. The court exercises its discretion to sentence the defendant consecutively as to counts 1 and 16. I find that this is extremely fair, reasonable, and proportional. And it's hard for a court to ever catch this when we're doing a sentencing. And I wish I could convey it well enough to an appellate court that will look at this case. It's not sitting here looking at the young women. It hasn't sat 4 feet away from them, listening to them testify, watching them testify, seeing the emotion on their face. No one can unring this bell. The remaining counts run consecutive. They're concurrently. Thank you. All right, Mr. Harrison, have you already gone over the rights and rights form? If
We
not,
have, Your Honor.
all right.
Do you have them or just Madam Clerk?
Madam Clerk does, thank you. All right, Mr. Salt, you have the right to appeal your conviction based upon the fact that you were found guilty at a trial by a jury. You have the right to file a claim of right to appeal, which means an automatic claim of right. Because I know you've already told me that you intend to file an appeal, what you need to do is you're going to place your initials on 1 copy. Doing so only acknowledges to me that you've received the other copy. Now I anticipate that you're going to fill it out right now. You have the right to have the court appoint an attorney to assist you on an appeal. And if you wish to have the court appoint an attorney, you complete the bottom half and return it to the court within 42 days. Again, facts of this case were quite traumatic. And I hope that someday the appellate court understands you've got to see the look on their faces now. Again, I only wish I could feel so much powerless here, but that's the best the court can do. Anything further, Mr. Kennard?
Yes, Judge, the victim here, Melinda, has requested restitution.
Oh, yes. What's that amount?
The amount of $4,800.
Court will order $4,800 in restitution. The likelihood of getting that's probably low, but okay. Mr. Carnes, anything further on behalf of the people?
No, Your Honor.
Thank you very much. All right. Mr. Harris, do you have that signed copy? Thank you.
For the record, I am providing you with the acknowledgement copy of the form. And Mr. Salter has also signed formally the request for appellate counsel.
The court acknowledges receipt of those 2 documents. I'll place those in the file. And I trust that will be organized. Folks, good luck to everyone. We're adjourned. Thank you.